Hi, Mr. Kanagaraj. Today I'll be talking about an ancient Latin maxim that has shaped the way we think about land ownership for centuries, which is Quis est solum ius est esqua ad coelum it ad inferos. Now, in this presentation, I'll explore how this principle works in today's English land law, focusing on three main dimensions, which is the surface, the space above, and the subterranean space below. We'll look at how the law balances private ownership with public interest and examine key cases and statutes and scholarly perspectives, including the important decision in the case of Vocado versus Star Energy UK. Now, to begin, the foundation of our discussion is the ancient Latin maxim, Quis est solum ius est esqua ad coelum it ad inferos, which translates to he who owns the land owns everything up to the heavens and down to the depths of the earth. Now, this maxim captures the traditional idea of three-dimensional land ownership, encompassing the surface, the airspace above, and the subterranean layers below. Essentially, it establishes that land ownership was once understood as absolute dominion in all directions. In its original context, it reflected the feudal notion that landowners had almost total control over their property, including the right to exclude others from using, flying over, or mining beneath the land. To understand the maxim fully, we also need to define what we mean by land. In legal terms, land is more than just the surface soil. As Professor J. A. Pai has explained, land includes the surface, the airspace above, and the earth beneath, together with everything naturally or legally attached to it. Now, similarly, in the Law of Property Act 1925, Section 205, subsection 1, Part 9, they provide a statutory definition stating that the land includes land of any tenure and mines and minerals, whether or not held apart from the surface, buildings, or parts of buildings and other corporeal hereditaments. Now, these definitions reinforce that land is a three-dimensional entity, not just a plot of ground, and the maxim essentially articulates this concept in succinct Latin form. Now, with this understanding of the maxim and the legal concept of land in mind, it becomes clearer why such a principle developed in the first place. Now, let's look at the historical roots of the maxim. This principle originated in early English common law during the feudal era, a time where land included absolute power, status, and wealth. Landowners were considered to have complete control in three dimensions over the surface, the air above, and the ground below. At the time, the rule was practical because the technology was limited. There were no airplanes flying overhead, no underground tunnels or pipelines. The simplicity of the maxim allowed landowners to exercise total dominion without any statutory interference. Now, under the traditional rule, the maxim was taken quite literally. Ownership of the land extended vertically all the way up into the sky and down to the center of the earth. Now, the landowner had the right to exclude anyone from entering, whether from the air or from below the surface. In essence, it was a law of absolute dominion. There were no statutory or public interest limitations, and land ownership was almost all encompassing, which is a true reflection of the feudal power structures. However, as society modernized, the absolute interpretation has become impractical. Technology, aviation, urban development, and energy extraction had all made it impossible to maintain unlimited ownership vertically. Today, the courts and statutes have qualified the maxim. Landowners now only enjoy the space they can reasonably use and enjoy. As academic Kevin Gray once said in Property in Thin Air, which is his book, the modern law recognizes only zones of effective control, meaning that ownership extends no higher or deeper than what is necessary for the landowner's ordinary use and enjoyment. This marks a shift from the ancient idea of absolute dominion to a principle grounded in practicality and public interest. Likewise, Thomas, in his book of Ownership of Subterranean Space in English Law, he highlights that subterranean ownership has undergone a similar transformation. Deep subsoil is now considered beyond meaningful private control, with legislation such as the Petroleum Act 1998 and Infrastructure Act 2015 transferring such rights to the Crown or licensed operators. In other words, the maxim no longer operates as an absolute rule. Instead, it serves as a conceptual starting point for defining land ownership's vertical extent, balancing private rights with public necessity and technological progress. Now, let's start with surface rights, which is really the heart of land ownership. This is a part of the land where we can actually see and walk on, and it's where the landowner's rights are most tangible. Essentially, surface rights allow the owner to live on, build on, farm, or otherwise use the land. Think of it as the foundation for everything else. It's from here that we measure what belongs to the landowner vertically, both above and below the ground, which ties directly to the ad coelum maxim. Now, when it comes to legal powers, a landowner has the right to develop or modify their property. Though, of course, this is subject to applying rules and building regulations. Another key aspect is the right to exclude others, which is central to protecting surface ownership. For example, in the case of Antique vs. Carrington, the court emphasized that any unauthorized entry onto someone's property, even without causing physical damage, was a violation of their rights. This case shows how seriously the law protects surface possession. Now, the surface is also important because it anchors vertical ownership. It acts as the reference point from which airspace above and the subsoil below are measured. But while historically the maxim suggested that ownership extended infinitely upwards and downwards, today the law interprets it more reasonably. Close look at what the landowner can practically use and enjoy rather than allowing absolute control. Of course, surface rights today are not completely unrestricted, as there is planning laws, environmental protection, and public infrastructure projects that can all limit what a landowner can do. Utilities, public rights of way, or compulsory acquisition might also come into play. Yet, despite these limits, the surface still represents the strongest layer of ownership. It's where the landowners have the clearest legal protection and most control. As the academic Chu has once said in 2017, the surface serves as the anchor for defining vertical property rights because it helps determine both the airspace above and the subsoil beneath, while also balancing private rights with public needs and technological developments. So service rights sets the stage and they give us a starting point for understanding the landowner's control, but they also hint at the limitation and questions that arise when we move above the land and into the airspace, which is exactly what we will be exploring next. Now, traditionally, under the maxim, landowners were believed to own everything above their land, extending theoretically up to the heavens. Now, this absolute view reflected the old conception of land as a vertically infinite asset. However, with the emergence of modern aviation, skyscrapers, and drone technology, courts recognized that unlimited ownership of airspace was impractical and inconsistent with public use. Case law shows how this evolution unfolded. In Kelson versus Imperial Tobacco, even a minor intrusion by a signboard into a neighbor's airspace was held to be trespass, confirming that the immediate airspace above the land belongs to the landowner. But later in Bernstein versus Skyviews, the court ruled that aerial photography from a reasonable height did not amount to trespass. Justice Griffiths introduced the reasonable height test, which became the cornerstone for distinguishing between private and public airspace. Similarly, in Anchor Brewhouse versus Berkeley House, a crane that swung into low-level airspace was held to have trespassed. This reaffirmed that the immediate usable airspace remains protected under property law. Statutory provisions now draw a clearer boundary, and that under the Civil Aviation Act 1982, lawful flights are immune from trespass claims, and the Air Navigation Order 2016, along with the CAA Drone Code, govern drone operations and privacy. As Chu has said in 2017, he explains in his Singaporean Journal of Legal Studies that airspace ownership today operates as a dual-layer system. The immediate layer remains private while the upper layer is public domain. Therefore, the literal interpretation of the maxim has evolved into a practical and functional framework, which is one that balances landowners' rights with technological advancement, aviation safety, and public freedom movement. Now, for subterranean rights, traditionally, the maxim also extended downwards, meaning ownership reached to the center of the earth. Now, landowners enjoyed total control over minerals, rocks, and all subsoil beneath their property. However, in the modern era, this absolute approach is no longer viable. Statutory intervention and technological development have greatly restricted private subterranean ownership. Now, the Petroleum Act 1998 and Coal Industry Act 1994 vest ownership of petroleum and coal in the Crown, while the Infrastructure Act 2015 allows certain deep drilling operations, such as fracking and geothermal exploration, to occur below 300 meters without the landowner's consent. Now, these laws reflect the public's interest in regulating underground resources for national benefit. From a practical perspective, the deep subsoil is largely inaccessible and has minimal private utility. Modern infrastructure such as transport tunnels, sewer systems, and fiber optic networks requires shared subterranean use. Thus, land ownership below the surface now functions within a cooperative legal model rather than one of absolute exclusion. Now, Morgan in 2013 argues that modern subterranean ownership is functional, that landowners control only the usable subsoil, while deep activities such as drilling or carbon storage lie outside private dominion. Now, the case of Bocado confirms this, that deep drilling can be trespassed, but only nominally, since petroleum belongs to the Crown and causes no real interference to the landowner. Now, Rigetti, another academic in 2017, similarly notes a shift towards correlative use, balancing private rights with resource access and environmental needs. Overall, subsurface ownership remains in principle, but is still tightly limited by statute, public interest, and technology. Now, to truly understand how the ancient maxim, the equivalent maxim, operates in the modern era, we turn to the landmark case of Bocado versus Star Energy UK Onshore Limited. Now, this case directly tested in Pharaoh's part of the maxim, which is the idea that land ownership extends all the way down to the depths of the earth. Now, here, Bocado SA had owned a land in Surrey, and Star Energy had obtained a government license to extract petroleum. Now, to reach the oil reserves, Star Energy had drilled several wells that passed 800 to 1,300 meters beneath Bocado's land without touching the surface. Bocado argued that under the ancient maxim, those subterranean layers still form part of their property, meaning that Star Energy had committed trespass beneath the land. Now, the legal issue was whether ownership truly extended that deep underground, or whether such depths were beyond private dominion. Now, especially when the drilling caused no physical interference at the surface and was conducted under statutory authority. Now, the UK Supreme Court agreed that a technical trespass had occurred. The court reaffirmed that the maxim still holds legal weight and that land ownership still does indeed extend beneath the surface. However, the judges also made it clear that this ownership is not absolute. As Lord Holme in the case explained, the principle must be applied reasonably since the depths of the earth are no longer within the control or the use of the landowner. Now, while Bocado won the point of law, damages were set at a mere £1,000, reflecting the minimal interference. Now, this token amount symbolized the modern compromise, which is recognizing ownership under the maxim but limiting its reach to what is practically useful. The decision is profoundly significant as it illustrates how the courts preserved the spirit of the maxim, yet reshape its scope to fit today's industrial and technological realities. It also directly influenced the Infrastructure Act 2015, which only permits companies to drill below 300 meters without informing the landowner, and showing the laws move away from the rigid feudal concepts towards a more functional model of land ownership. Now, academic Kevin Gray said in 1991 that modern property law defines ownership by practical control rather than limitless theoretical rights, treating airspace and subsoil as zones of useful, not absolute dominion. Now, academic W.A. Thomas has similarly noted that deep underground strata have no real utility for surface owners, so the law no longer treats them as part of their meaningful ownership. Both perspectives align with the Bocado case, which recognizes ownership in principle but limits it where it serves no practical purpose. Now, in conclusion, modern law still treats land as three-dimensional, but the old ad coelum maxim now operates only as a guiding principle, as statute and case law limit ownership to the airspace and subsoil to what a landowner can realistically use. Now, public regulations govern high altitude airspace and deep underground resources, while cases like the Bocado case show that although trespass can occur at depth, only minimal damages will follow. Now, scholars view this as a shift from absolute ownership to practical zones of control, reflecting a move towards a more functional and publicly minded model of property, which benefits pretty much the public and everyone all around as a result. Anyways, that is my presentation. And finally, these are my references for all the cases and statutes, books and journals of all the academics that I've used in this presentation. I'm sorry if I talked a bit too fast, sir. Yeah, thank you very much. It's been quite fun doing this presentation. Thank you very much, sir.